tuition in the Act itself. If you look at the structure of Section 1412A10, Congress subdivided the universe of children being educated in private schools between those who are placed by the public agency into the private school and those who are placed by their parents. Those children who are placed into the private school by a public agency are still guaranteed an appropriate education at no cost to their parents.
Counselor, can I just ask you, you've mentioned earlier that the parent has to act reasonably, has to give notice at the next meeting or 10 days. What if the parent is acting reasonably because this is harmful to their child? The child is in the school for 2 days and they know that this is harmful to the child. So that would not satisfy the statute, that knowing that this is harmful to the child, rather than waiting 10 days and going through all of this, they still wouldn't satisfy the requirements?
Your Honor, to satisfy the requirements for tuition reimbursement, as long as that parent had provided the required notice, if 2 days was enough to reasonably conclude that that IEP was not working and the school was not cooperating to make it better, in that case, a parent would be eligible for tuition reimbursement and could bring that claim.
But doesn't that seem arbitrary?
No, Your Honor, and that's simply because the appropriate length of time would vary under the circumstances. If when the parent places their child into that program, the parent realizes that it's not working.
So if you go into the program for a half an hour, that's enough. If you know it's not working, then that's reasonable, and you can get reimbursement. But if you realize at the outset that the IEP is totally absurd by any reasonable view of it, you can't put that child directly into the private school.
Your Honor, it's highly unlikely that placing a child into an IEP placement for a half hour would be enough.
Yeah, but we knew it was bad, but I want to comply with your rationale or your reading of the statute. And if we take your reading of the statute, I have to do that totally unnecessary, totally, again, just for no rational reason, take that act to get under the umbrella of the statute, and then it's okay. Because we know it's no good to begin with, but I'm going to put in my half an hour. Isn't that, again, making someone do something that would seem to be contrary to what the statute is trying to do, to provide reimbursement in a situation where you can't get the adequate education at the public school?
Well, Justice Littman, there are a number of reasons that Congress would have imposed this requirement. For one reason, as this court described in Schaefer v. Weiss, the cooperative process between parents and schools is really the core of the statute. And the IEP placement process is
But you already said that each case is different, and it can be the most minimal involvement, whether it's 2 days you were talking about before. How far do you take this scenario? Does the statute become ridiculous in its practical application if you're saying that 2 days is enough, and I say, gee, if 2 days is enough, maybe a half an hour is enough? How far do we take this literal reading of the statute that you're giving it to the point where the statute doesn't make any sense? It's got to make practical sense. It has to work. The law doesn't make sense if it doesn't work.
Your Honor, again, the plain language places these conditions on one remedy that the statute provides, and that's retroactive tuition reimbursement. It's important to recognize that many other remedies would be available here, even if tuition reimbursement weren't. Under Section 1415, while that no longer is a source for tuition reimbursement claims outside of the conditions set forth in 1412, that parent who's dissatisfied with that plan still could request a due process hearing and seek declaratory relief or seek injunctive.
Right, but the bottom line is your position is that conceivably a half an hour is sufficient and gets you in under the statute.
Your Honor, I believe that would be highly unlikely, but appropriately Congress left unspecified the minimum time period.
But there could be situations where 15 to 20 minutes would get it, right?
Your Honor, that seemed I would disagree that
likely or unlikely. I mean, is that a possible in the universe of possible outcomes under this statute? Is 15 minutes one of them?
Your Honor, it is possible that would be one of them, but at
Sorry?
it is possible that that would be one
So
of them.
is that a yes or a no?
Yes, Your Honor.
Oh,
but at
okay.
the very least, what that would do, if that parent became dissatisfied reasonably after 15 minutes, the parent still would have to provide 10 business days notice of their intent to withdraw their child, and that's before they actually withdraw their child.
With the three circuits, again, that have gone the other way, do you distinguish any of those cases, or do you think they're all three wrong?
Your Honor, our contention is they're just simply wrong.
So you're not distinguishing them on the facts?
No, Your Honor. It's simply that they misconstrued the applicability of Section 1415 to situations where a child has never received public special education
And
services.
all these are these federal courts that your partner put such great stock in?
Yes, Your Honor.
I see.
Aside from the actual waste of time the child would have in a failed program, wouldn't this actually cost the district more money? Because you have to pay for the IEP, and then ultimately you'd have to reimburse private tuition.
Your Honor, my time is up. May I answer the question?
Sure.
Thank you.
Lee.
Your Honor, in reality, the school districts will actually save money by requiring this tryout period, and that's because it gives parents and schools a last good faith chance to work out their differences in the face of facts before going to litigation. And both the cost of the tuition reimbursement itself and the cost of the litigation are incredibly costly. And because the text of the statute requires that George have tried out this placement before his parents sought tuition reimbursement, we ask that the 14th Circuit's decision be affirmed. Thank you.
Now, all this money we're talking about, by the way, is not state money, it's federal money, right?
Your Honor, the IDEA contemplates that Congress would fund 40% of the cost of special education. In reality, it's between 8 and 17%. So it would be a combination of the two.
Thank you.
Thank you.
Thank you, counsel. Well argued on both sides. We will. I'm sorry, you've reserved 2 minutes. I'm reminded.
May it please the Court, I have 2 points of rebuttal. First, respondents' characterization of the individualized assessments rule is patently wrong. This Court has never limited the application of that rule to the unemployment context, for it was applied in Church of Lukumi, which had nothing to do with employment. Furthermore, in City of Bernie versus Flores, this Court did not hold that zoning laws are per se neutral laws of general applicability. Rather, this Court noted in dicta that certain zoning laws are neutral laws. And certain zoning laws indeed do have individualized assessments, and this Court has held that when individualized assessments substantially burden the exercise of religion, they should be subjected to strict scrutiny. Second, if an IEP is facially inappropriate, then a child should not be forced into an inappropriate program for an arbitrary and unspecified period of time. And respondent wants a child to stay in that program for a reasonable period of time. However, a parent does not know what is reasonable. Keeping a child in an inappropriate program is directly contrary to the primary purpose of IDEA, which is to protect the rights of parents and children.
Only one question at this late hour. Aren't all the zoning decisions in a way, though, individualized assessment? Isn't that the weakness in that argument? The zoning board hears, the zoning board decides. It always has to do it case by case and individually.
Your Honor, many zoning laws do have individualized assessments. However, many do not. For example, height restrictions that are applied equally to all parties, or historic preservation laws that are applied equally to all parties, or if a particular area is zoned purely residential, those would be neutral laws. But when a zoning board has the broad discretion to determine whether a party should be exempt from a law or not, those involve individualized assessment.